Okay, good morning. This is Senate Health and Welfare. It is March 9th, 2022, and we are beginning our meeting this morning. We're looking at bills that we've been working on for a while and hopefully be able to act on one or more of them. We're looking at S72, which is the Interstate Compact for the Placement of Children right now. So we'll just begin with that and then we'll talk about the other bills as we get to them. So Michelle and Trissy, thank you so much for being with us 2 days in a row at 8:30. Greatly appreciated. So why don't you, we asked, I think, just to know where the new language is in the compact bill. So why don't I give it back to you and let you take us through.
So Senator Lyons, would it be so there were 3 things that you mentioned yesterday. One was to check on a citation, and
Yep.
I just wanted to kind of and then the other one was also kind of for a little more information about the changes to subchapter 2 that were at the end.
Yes.
And so is it okay if I just go through those with you real quickly and then we can bring
Absolutely. Any way you like, yeah, whatever makes sense, that's fine.
Okay, great. So let me share the screen. So you had asked about, and let me see if I can do a find, sorry, on this document.
Section 2.
So you had asked for about whether or not this reference to, let me see it, 5907. Oh, right. So at the very end of the bill in subchapter 2 on page 41, section 5925, where it talks about the Secretary of Human Services is authorized to appoint a compact administrator in accordance with the terms of 5907. And
yes.
You had said, oh, that seems weird. It doesn't seem like the right section. And so I went back and double checked, and you're right, it kind of seems a little odd because if you just look at the heading for 5907, it talks about placing agency responsibility. But if you go down to subsection F and G, remember we talked about those 2 sections around the advisory council and the subsection G, which is each member state shall establish a central compact office. So that is the right reference.
Okay, all right, good, thank you.
But thank you for pointing that out, because we did have to move a lot of stuff around, and sometimes, you know, we miss those as we're reorganizing everything. So I appreciate you bird dogging that for me.
Can I ask a question? I think related actually to the advisory council. So there's a possibility that as we look at the child advocate bill, that we will be asked, at some point in the state, we're going to have a child advocate. So how do we put the child advocate into this process now, if at all, or do we simply wait and have the child advocate be someone accessible or involved in this process? That's a different question, and
I don't know anything about the child advocate bill, but I'm happy to chat with Tracy, separately.
Yeah, it's just a question.
Yeah, okay. Who's doing the child advocate? Is that Katie?
Yep, I believe that is Katie. Yes, that's right. It's an H bill, and it is in our committee. I did 265. Can you see, or 462 down there? Go down.
265.
H265.
Okay, great.
Just we don't need to have this answer right away, but
okay.
It might be.
Yeah, we could do it when we do that bill.
That's what I was going to ask.
Yeah.
If we could put the reference into the child advocate duties and responsibilities or work, we don't have to have it in the compact. That's the question.
Right, you don't want to mess with the language in the compact.
We don't want to mess with it. We definitely don't. Okay,
So, I'll touch base with Katie, but you're trying to, no, you don't have, because it's a House bill, you don't need it. Okay, great. So if that can just kind of.
yeah, I don't think we need this right away. It was just a
Right.
thought. And we can deal with it when we have the H bill before us. But just wanted your thoughts on it.
Sure,
Okay.
okay.
Senator Hooker has a question.
Yeah, Michelle, one of the things that we talked about in the bill is the placement out of state and who does the assessment of the placement. And I think it says that the receiving state is doing the assessment for the child.
Correct.
Is the sending state not involved at all? I know that they're supposed to be complying with the standards of the sending state, but is the sending state not involved at all to know where that child?
In the assessment of whether or not it's appropriate?
Correct.
It doesn't appear to be, but Tracy may have a little more information about how that tends to kind of work now with the kind of, because there's rules in place now with the existing compact.
So I can give some information towards that. So currently right now, when we send over a requesting a home study and approval for placement in another state, we're putting together a pretty large packet of information that includes the case plan, the social history, any information regarding that family member or relative or resource family that we're looking to place the child with. And I always recommend for workers in each state in this to talk to each other and communicate, but that's not something that's required. Generally, it's the receiving state that's conducting the entire assessment. Frequently, they will call the local workers here in the state of Vermont to get if they need further information or have questions about the situation. But the burden is 100% on the receiving state for it to complete the assessment and to make the recommendations.
So there's no requirement that they check with each other?
There is not. However, in most situations, that practice does take place.
It just seems strange that, the state that knows the child would not have something, sort of a more hands-on part in placing that child.
So we would have, if the receiving state approved the placement, it would be up to us as to whether or not we placed the child in the other state. We would still maintain jurisdiction. We would still be case planning. All the court would still be here in the state of Vermont. But ultimately, the other state would be providing just courtesy monthly supervision of the child for us in the home. And if they no longer deemed the placement to be in the best interest of the child, then that decision they could make and ask us to return the child. But ultimately, it would still be the sending state's responsibility and still their case and their child.
Okay. Thank you.
That answer your question?
Yeah, I think so.
That's a good question. That's really complicated.
Yeah, I mean,
Good, that's good clarification. That's very helpful.
thank you.
Okay,
So I'm just going to go to the second issue just really briefly, which is that on subchapter 2, which starts on page 39. So that this is replacing the subchapter 2 that's in the existing compact. And the major difference, and I think Tracy mentioned this yesterday, is that it would apply to with regard to procedural due process for youth being placed out of state to all kids who are in DCF custody. And so what you have here is the main difference is this new section 5924, which talks about DCF may place the child in another state, and then clarifying that there's procedural due process for all kids who are in custody of DCF. I'll show you what the current law looks like. Let's see if I can switch that. Can you see that?
yeah,
Okay, great. So if we're looking at subchapter 2 here in the existing compact, you'll see that there's two sections here, one for placement of delinquent children, and then the second one, placement of neglected or unmanageable children. And so this is just combining the two into this new section for what you have here for placement of a child in another state, and then just tweaking the language. So so I just wanted to note that on this particular section.
Are there any implications of putting those two cohorts of kids together in terms of, I mean, they'll still have separate treatment and supports. We're not suggesting that they would be treated similarly when they're set out of state or in any kind of.
No.
Okay.
And the language, the delinquent and unmanageable children, that language has changed, right? That seems old.
I'm not usually your person who works on juvenile issues, which is so why I'm struggling a little bit with this one. I'm just kind of pinch hitting. But I don't know about unmanageable, but it is delinquency, and I don't know if unmanageable is still used. I think it may be, but Tracy may know.
In the statute, it still is referred to as unmanageable, but we have moved away from that language as a department.
Okay, that's good.
What seems
very judgy.
Right.
What's the current language?
I believe that we're moving more towards beyond the control of the parent in the Chin-C cases. The one thing I will say is that the language in too fast.
Sorry.
I think it's in subchapter 2 of the old the current compact. I think it's 5925 and 5926.
Right.
The language is exactly the same. It's just the headers that are different as to the different types of kids in terms of how they're in our custody. That's the only difference in the current statute.
Okay.
All right, good. We'll check in with Katie.
And so that's it for me. And I think when Tracy talks about the kind of the summary of the changes, again, if you're going to vote this out, whoever's going to report it on the floor, I can go through next week and identify the particular sections and things like that for you for reference, if that's helpful for floor debate. Although I don't know that you'll get a lot. I mean, I guess maybe you might get a lot of questions, but I think I don't know that people are going to want to dig into the language too deeply on this one.
We might get questions, but not a lot of debate.
Right.
Did you or Tracy look into the question about the military kids from overseas and what happens to them?
You mean like what applies? No, but you know what I'll do is I'll see if one of our interns can maybe work on that this week, and so you can kind of have some information. Okay, that would be great. It's obviously not going to affect this bill, but I mean, curious. So that's a perfect intern project. Thank you, Michelle. Sure.
So I put the question out to our national office. So when I receive the response back, who should I send that to?
Why don't you send it to me?
Okay.
And then I will, if I need to have a student, one of the law students kind of dig a little further or something, or pull some some federal statutes up and stuff, I can have them do that. That'd be great.
Thank you.
Yeah, thank you both.
Okay. Go ahead.
So that's it for me right there. So I think maybe Tracy can talk about the specific changes a little bit, and I will help where I can.
Okay.
So I emailed Aaron this morning. I don't know if Aaron, you got my email.
He posted it.
Would you like me to put it up on the screen?
Sure, that we like that.
Okay.
No, it's slides.
It's new.
It's called Differences Between Old and New.
Ah.
Okay, and as you were saying, we don't have specific references to the bill, but we'll be able to get those. And I think, we have a lot of them as we were going through yesterday, but this is terrific So Tracy, go ahead, please.
So I don't see it on my screen, but can you guys see it? I have a copy, my own copy.
Oh,
We have it on our screens, our
Oh, okay. Then
Michelle,
that's all that matters. That you guys
Yep, I'm
can see
gonna put it on, I'm just grabbing it on here, so. let's see.
So I think that the major difference for the compact that's really is that it's going to update the legal framework to address the needs and infrastructure for placing children currently. So the way that it's structured right now, it's very difficult for us to make any changes that need to in order to come along with what's going on in the times. And so in the future, we won't need to come back and ask the legislator to adopt a new compact because we will be able to change it as needed and as the times go. And that's probably one of the most important pieces, differences. So the new compact, it distinguishes the difference between an assessment and a home study. The current compact is silent on it. It doesn't explain the differences. It's going to create one home study template that would be used by all jurisdictions. Right now, every state, and even there are 3 decentralized states, and each of those counties have their own home study template, their own requirements for assessment and home study. And those are some of the reasons that lead to such delays with completing in terms of getting an interstate decision as to whether a child can be placed in another state. This having one home study template is going to lead to timely placements of children with their family members in other states. It's also clarifying the applicability of the compact to non-custodial parents. Right now, there are a variety of states that have Supreme Court rulings talking about with decisions that conflict with one another as to whether or not the compact applies to non-custodial parents in the context of a child protection proceeding. And so what it's doing is it's moving all the information regarding non-custodial parents. Right now, that information lives in the regulations, the rules, and it's going to move it up to the articles of organization, which is what you guys would be adopting here now. And it would be in every state statute. It's going to provide an administrative review of denials in the receiving state. Under the current compact, there's no requirement. It's up to each state to determine whether or not they want to have an administrative review process for denials. The new compact is only going to require notification to a state when a child is placed in a residential program. Right now, you need prior approval of placement in order for a child to be placed in an out-of-state residential program. The other differences are that it's going to be a one state, one vote body to make rules and regulations for the signatories and provides opportunity for public comment and input. Right now, that's not something that exists within the current compact. And this is going to be part of what allows us to make changes to rules more frequently so that we can remain current. And then the last piece is that the new compact is going to strengthen enforcement. It's going to provide mediation and binding dispute resolution, can provide remedial training and technical assistance. And I have to say the enforcement piece is really a motivating factor for states to be in compliance. The other compact that I'm responsible for, the ICJ compact, has very clear enforcement, and it is a huge motivating factor for states to operate in following the rules. So those are the key points that I thought were important in terms of the biggest differences between the new and the new compact and the current compact. Does anybody have any questions about that?
yeah, no, thank you. This is very helpful. Having a list is great. And if we can, going forward, get a link to the sections of the bill, that would be even more helpful to whoever is presenting the bill on the floor. The question I have for you is, you've obviously been our representative to the compact. There are, 13 states currently in the compact. Has there been an advantage to Vermont in having you be, sort of first on board with this and being able to make these improvements?
So the advantage of Vermont adopting early, being an early adopter, is that we would be so the states, the first 35 states that adopt the compact, those are the states that will be at the table to make the rules and regulations. And so the state of Vermont would be, as small of a state we would have the opportunity to impact as to how the compact is going to work and operate for the entire country. And so there is a huge advantage for us to be at the table in order to do that, which is one of the reasons why I've been really strongly advocating for this bill to be passed.
Chrissy, thank you. It's great to know that we have a big advocate, hopefully at the table. The first bullet point that you point out, the new compact updates the legal framework. And you said that that the compact would have ability to make changes without coming back to the, how does that work? Because if we're literally putting this in our statute, if there are changes made to it, wouldn't we have to update our statutes?
So we would be making changes to the rules. So the rules are what guide the work of the compact. And so if you're going to there's different requirements as what you need to do in order to change articles of organization for compacts. And I'm not familiar with that process 100%, but I can find out for you. The rules, so for example, we had to update our current compact, some of the rules so that we could, in November, we had to have an emergency in-person meeting because the way that the current compact is structured, we're not allowed to vote virtually. We're not allowed to have business our business meetings virtually. We couldn't change the officers virtually. And so we had to come together to make changes so that we could then proceed in the future, because we had been in a holding pattern for 2 years with COVID of not being able to create any emergency rules. And everybody, myself included, who was on the executive committee was kind of stuck because new people couldn't be voted in because we were unable to meet in person. So that's kind of an example of
so it would be changing the rules, not changing the legal framework for the rules.
Correct.
Okay, so you might want to just clarify that bullet point, because what it sounds like is you could change the actual compact, not the rules that govern the compact. Do you understand what I mean? Yeah. Oh, you're muted.
You're muted.
Yep. So I was just writing it down, what you were saying.
Oh, okay, great. Thank you.
Okay, any other questions on this? This is very helpful. Thank you for bringing us, and as you clarify this a little bit and add the statutory references, that would be extremely helpful to us. And I think unless there are other questions, I think we're good. You can take the screen down, Michelle. That's better. Now we can see you. So, thanks a lot. I think we'll just stay connected on this.
Should we?
Any other questions? Any other questions? Okay, we're good. I think what we'll do is we're going to move right along to S-285 at this point, and we'll probably come back just before we break today, and we will more than likely vote. I would accept the motion to vote on the bill today so we can move ahead, so you get a sense of where we are with it. And I understand that the whole editing process is a bit backed up, so I'm not thinking this will come out quickly.
Well, it doesnn't need to go through editing. I mean, I think because
You're right. We're just
it's a compact. I think I think you're just looking at a up or down vote on the bill as introduced.
Okay, we're good. All right, so thank you so much. And Senator Tianzini has disappeared. Thank you. Take care. All right, good.
I like that view.
It's better.
It's better.
Right, so you would look at this, just, we worked on that this morning to make sure that people could, when we're looking at the screen, people know that we're paying attention. The other view, we were looking off in the wrong direction.
Right, it was like,
Well, I got folks in my committee that have to turn around to see the screen.
yeah, it's
Then
awful.
all they do is get the backs of their heads.
Yeah,
Yeah, and it's a split screen, so it's,
Yeah.
I'm like half on one screen, half on the other screen.
so
It's
that's-
weird.
But we haven't found, because we don't have a flat wall directly in front of the table, there's
That's
a door.
you have the door.
So ours is kind of kitty corner. Jackson.
Yeah, why don't we let folks in? We got a bunch of people on S-285. Jen, is Jen here? Is she here? There she is. Oh my God. It's like,
It's magic, Jen.
let me just say, I would just like to say that yesterday I was remiss in not saying how fabulous it was to see 2 ledge councils and a JFO person in our room. It was just really great.
Maybe.
On the committee, we haven't met as a committee before. It was just great in person. All right, so our, is everyone in? Let all the witnesses in. They can stay muted and off screen while we go through the bill.
Everyone that's here right now is in.
All right.
So they're just figuring it out.
Huh?
Rebecca and Robin are here, the video was off.
Oh, okay, okay, I got it. All right, good. All right, so we are taking up S-285, and by way of, it's a new draft. And it is a draft that Jen and I have worked on together and with others. So there's a good deal of work embedded in the draft based on the testimony that we have heard.
I have to go get my iPad. I just realized I left it.
Okay, let's go off YouTube for a minute.